everybody, we're going to get started. I don't want to say it for the 5th time if you've heard it every single time, but if you're new and didn't hear the Wi-Fi, it's 1981 is the promotional code. So I'm here to introduce Magistrate of the St. Joseph Probate Court, Graham Polondo. He's been doing that since 2013, primarily hearing juvenile delinquency cases and occasional state and guardianship cases, and also a regular family law docket. So he's an author. Some of his written work includes author of volume 14, 15, and 15A of the Indiana Practice series of legal treatises which cover family law. He recently assumed the duty of updating Judge Robert R. Miller Jr.'s volumes 12, 13, and 13B of the same series, which cover evidence, which is why he is our speaker here today, and published 6 additional articles in various professional and academic journals. Previously, he was a lecturer in sociology and social work at Manchester University in North Manchester, Indiana. He taught 2 courses, criminal behavior, the criminal justice system, and youth in the juvenile justice system. His professional activities include past chair and member of the Indiana State Bar Association's Legal Ethics Committee, member of the National Council of Juvenile and Family Court Judges, secretary of the Indiana Council of Juvenile and Family Court Judges, and member of the Indiana Office of Court Services Juvenile Justice Improvement Committee. Most of us, though, just know him as Judge.
All of you for coming today. I am indeed taking over the evidence books that Judge Miller had written for so many years. And me taking over those books might remind you of a news story from a few years ago. There was this beautiful painting dating back to the Renaissance in Spain. Looked like that. And they decided to update it. And it turned out like that. And that's how I feel taking over this work. So please excuse the end product. Doing the 2 sets of books, taking over these evidence books and having previously done the family law books now for several years, has given me a bit of an interesting perspective on the differences between family law and evidence law. And I think they have a very different set of pitfalls, which is the theme for the talk here today. The pitfalls in family law are, I think, first, the fact that we have constant statutory revision in family law. It's so frustrating, and I'm sure you've been in the same boat, where you think you mastered an area, especially with respect to the statutory area of family law, and then a few years later it gets completely overhauled and you have to start from scratch. That's a difficulty. There are a ton of family law cases. I would guess there's probably about 2 to 3 cases per week. Anywhere from 1 to 2 of those are going to be published, and it just takes a really long time to analyze those, digest them, fit them in with other cases. And that can be especially difficult because a lot of the family law cases conflict. Sometimes explicitly. We all know we don't have horizontal stare decisis in Indiana, and so the Court of Appeals, different panels of the Court of Appeals don't feel bound by prior panels. So you can have explicit conflict where they say we're not following this old case. Sometimes you have implicit conflict where they don't acknowledge the other case. And so it's just a very time-consuming enterprise keeping up with family law. I don't think that's the case in evidence. Rather, I think the evidence statutes, which are really essentially the rules of evidence, are remarkably stable. They're largely the same today as they were when I was in law school, probably when you were in law school as well. And we have far, far, far fewer cases when it comes to evidence law. I would say maybe 1 every 2 weeks, generally going to be published, but they're generally not particularly earth-shattering cases either. They tend to just be new explanations of very old rules. So what gives us trouble in evidence? Here, I think I've identified a few pitfalls, and it's the framework that we're going to use for the talk here today. First, I think evidence is hard. The idea of statements not being offered, for their truth, or the distinction between testimony on someone's opinion of another witness's truthfulness versus their reputation for truthfulness, those 2 things are very hard to suss out, at least they are for me. You have to deal with these things at a very high level of abstraction. Second, I learn best by learning the policies behind things. What are we trying to accomplish? And yet with evidence, a lot of times what we're trying to accomplish is at odds with something else that we're trying to accomplish. overall with evidence. We want to discern the truth of the matter. We want to find out what happened. And so we're going to try to present evidence on those sorts of things, except we also want to encourage settlement negotiations. So even if that's relevant, we're not going to let you talk about it. Or we want to encourage subsequent remedial measures. So even if that's relevant, we're not going to let you talk about it. And trying to suss out those things in your head, again, is difficult, at least for me. We use a lot of jargon when it comes to evidence. If I say that bolstering of a witness is prohibited, most people would say, yes, that's true. But what is bolstering? What do we mean by that? And is it really prohibited? If I say that there's a rule of completeness, what does that allow? And it turns out that a lot of times the names that we use for things can obscure their true meaning and send us on the wrong path. And then finally, we have federal versus state rule differences. I said I learned the rules of evidence, but of course I didn't learn the Indiana rules of evidence, and I'm sure very few of you did as well. We learned the federal rules. They're largely the same as the Indiana rules of evidence, but they are not completely the same. And treating them as exactly the same can lead to some further pitfalls. So I was asked to speak on evidentiary issues that we as judicial officers are seeing in our courts, and I have to say that was a little bit difficult because I think evidence is an area in which our bar is particularly strong. But I do see some things that I can offer an opinion on using this framework, and I'm going to do that. But before I do that, whenever I speak, I offer a disclaimer. The Code of Judicial Conduct prohibits me from making pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of judicial office. So of course I'm not going to do that here, but I'm actually going to go a little bit further, which is first to point out that when we talk about the law in general terms, we lose the factual context that can be very, very important to deciding individual cases. There are times when I think about a legal issue and I think, well, this is clearly the case. In this situation, the judge should do X. And then I come across that situation and I think, why? Because there's a fact in this particular case that's in front of me that I hadn't thought of before. And that's of course going to be true here. Second, I'm obviously making all of these statements without the benefit of the arguments of counsel. That's one of the best parts of my job, is looking at something and having a lawyer say, well, what about this or what about that, and me thinking about it in a new light. I obviously won't have that here, although I would appreciate if anybody has a comment, question, thought, please, I would welcome a dialogue. So let's get into it. And the first pitfall that I see, the first area where there are pitfalls that I see, is with the scope of the rules of evidence themselves. We learn all these rules, we study them, we read the cases interpreting them, but we ought to ask, do they even apply in our particular case? Well, the rules tell us when they apply to the proceedings in this state, with the exceptions stated in the rule. What are the exceptions? Well, there's a fairly long list there. I apologize for the small print, but I wanted to make sure I got everything all on one slide. And I was asked to focus this talk primarily on criminal proceedings, and I think it's interesting that with one exception, all of these are criminal, or what I would call quasi-criminal proceedings. Judge Miller points out that there is one potential other proceeding that's not listed in the rule, and that's post-conviction relief proceedings. He suggests that because the PCR rules expressly allow for the admission of affidavits for their truth, i.e. hearsay, perhaps the rules don't apply there as well, even though they are not listed in Rule 101A. Now, we have this list. It's relatively clear. It's right there in the very first rule, and yet I will frequently get in my preliminary juvenile matters and in my proceedings relating to probation and sentencing objections based on the rules of evidence. Most often the objection is hearsay. And so we ought to ask, well, is that a legitimate objection? If the rules of evidence don't apply, does it make any sense to say objection hearsay? And the short answer is that it's complicated. The better objection would be to say, this is unreliable hearsay. This comes from what I still think to be the leading case in this area. It's a 1999 Indiana Supreme Court case, Cox versus State. We are to consider evidence only that has substantial indicia of reliability. When we do so, the fact that there are no rules, essentially, means that judges have a particular role as gatekeepers, in assessing the weight, sufficiency, and reliability of the evidence. Put a pin in weight for a moment, if you would. But very clearly, this is not subject to the rules of evidence. Now, I think this makes some sense in the abstract. We have a provision that says the rules of evidence don't apply. Presumably that provision is there for a reason. We don't want a full-blown criminal trial in every single probation revocation case. We don't want to have to call in all the links in the chain of hearsay, and so we're going to allow for it under certain circumstances. But we also don't want to say that literally everything comes in. It's just a free-for-all. And so we have this sort of moderate course with this indicia of reliability standard. But I will say that while I understand the standard, I do think it is somewhat problematic in practice because it conflates things that we generally want to keep separate, which is the idea of the weight to be given certain evidence and the admissibility of certain evidence. The rules of evidence do a really, really good job of keeping those two things separate. They tell us what goes before the fact finder, not what the fact finder should think about those things. It's process-based, it's not result-based. On the other hand, this standard is expressly result-based. It asks us to lift up the blindfold a little bit and figure out what we're going to believe before we decide whether or not it's admissible. I can come up with an example of evidence that is clearly admissible under the rules and yet not particularly weighty. If I have the testimony of a witness who is financially interested in the outcome of the case and they have very poor eyesight and hearing and they have 10 convictions for crimes of dishonesty, that's probably not going to be a particularly persuasive witness, but there's nothing wrong with that witness testifying. That in and of itself is not a reason to keep that witness from testifying. And yet under this standard, it might be. And I cannot come up with the opposite. I cannot come up with an example of evidence that would be reliable and yet wouldn't be persuasive, because I think those two things are largely synonymous. And I would point out that in a very analogous situation, which is the idea of confrontation, the U.S. Supreme Court has expressly rejected conflating these two things, that we ought to keep separate the substance and procedure. Now, in the standard's defense, the idea might be, well, this is somewhat like summary judgment. Summary judgment is renewed de novo at the Court of Appeals. Why? Because they can look at a paper record just as well as the trial court can. And the thinking here seems to be, well, we can look at hearsay just as well as the trial court can. But I'm not sure that's true. A lot of times these things are somewhat unclear mixes of a little bit of hearsay and a little bit of the witness's actual testimony, as we will see in practice. But right or wrong, good or bad, this is the standard that we have. And so I want to go through a few examples of how it looks in practice. The first three cases are examples of affirmances of the trial court's admission of the evidence in these types of proceedings. First, we have drug test results that are prepared by a laboratory. The laboratory, the sort of quasi-official nature of those seem to be the key in that case. I also have that case up there because it expressly rejected an invitation to revisit this standard after Crawford. The Court of Appeals held, I'm sorry, the Supreme Court held that the increased level of confrontation needed in a criminal trial, not necessary in one of these excluded proceedings. Second, also affirmed testimony that, quote, other officers told the witness that they had found a handgun at the home of the probationer. And I have this case up there because, to me, this does not seem to be a particularly strong showing of reliability. And in fact, I deliberately have officers in quotation marks there because the Court of Appeals drops a footnote indicating we don't even know what kind of officers these folks were. It sort of suggested law enforcement officers, but other areas suggest that these are community corrections officers. And in fact, the witness had indicated that she had worked with these folks. She was a community corrections officer. And in the past, she had found their information to be reliable. Good enough under this standard. And then finally, I have another example. Again, these are just examples. This is not a comprehensive list. We have essentially double hearsay. And not only double hearsay, but we have an unknown declarant in the middle of that double hearsay. We have someone at school who indicates that the child was struck by the probationer. That was held to be good enough. I have where the caseworker viewed the alleged injury caused by this strike, whether that was sufficient corroboration, whether that was the reason that this got over the reliability threshold, I don't know. But I think the point of the case is that this bar is very, very, very low. It is, however, a real bar. There are cases that do reverse the admission of evidence, and I have a couple of them there. The first is, we saw earlier that double hearsay is okay. Triple hearsay is apparently where the line is drawn. This is not going to be good enough. And then finally, testimony that, quote, a mapping system indicated that the probationer was not where he should be. Also not good enough. And again, I have mapping system in quotation marks. That's literally the entire evidence. Nothing about what it was, what its reliability was, nothing at all, just mapping. Any comments, questions, thoughts on that before we move on? All right, here's the part I'm dreading. I already talked about it. Character for truthfulness, because I keep saying it wrong. And the fact that I keep saying it wrong indicates, I think, just how difficult it is. The various rules that we have governing testimony on a witness's character or truthfulness. Here we have a lot of the pitfalls that I mentioned earlier. First, this is really not intuitive, at least for me. I'm not sure I completely understand the distinction between testimony about another witness's reputation for truthful character and my own opinion of that witness's truthful character. In fact, I'm tempted to say that distinction, at least in practice, really doesn't exist. I think it's very unlikely that I would say, you know what, I'm a member of the South Bend legal community. Everybody in our legal community thinks that Andrea Halpin is a liar, but I believe her. That does not seem to be plausible. Rather, I think we're going to find the reputations that accord with our own beliefs. So again, not entirely sure what the distinction is. Excuse me. It's also very difficult to cross-examine a reputation. How do we prove that a reputation exists or doesn't exist? How would I impeach a witness that says that this witness has a reputation for truthful character or untruthful character? There's really nothing I can point to. I suppose I can get into a quantitative witness contest where we just bring in the number of people within the community. We have to define that community and then make a decision, but that seems very, very cumbersome. Also, if we have a basic requirement of personal knowledge for a witness to testify under Rule 602, and we do, then how does one become personally acquainted with another person's reputation for truthfulness? And if we're talking about the opinion testimony on truthful character, and that opinion testimony is subject to the general limitations on opinion testimony from Rule 701, what does it mean to have your opinion of someone else's truthful or untruthful character be rationally based on your own perceptions? And then finally, I think we have a real issue of relevance and reliability. Let's say that we're able to solve all of those problems. I'm not sure that proving that someone has a reputation for truthfulness really tells us all that much about whether we ought to believe this witness under these circumstances. We can all think of people who had rock-solid reputations for honesty and yet turned out to be frauds. And I imagine vice versa as well. This reminds me of one of my favorite quotes, Charles Darwin. Great is the power of studying misrepresentation. I can't even get people to believe the proper thing about what I wrote in a book that's one of the most widely read books probably ever. Why? Because I can't keep up with the rumor mill. And I think that's probably true of this sort of evidence as well. I think we also have a jargon issue. This is where the bolstering comes in. Doesn't this sort of evidence go against our entire idea that a witness's credibility should stand or fall based on the standard forms of impeachment like bias, prejudice, lack of capacity, that sort of thing, all things that are intrinsic to the trial? Isn't bolstering of this sort the idea that Jack should be believed because Jill thinks Jack is generally truthful? Isn't that exactly what we try to keep out? And in fact, doesn't that go against the entire idea of Rule 404, which generally says, well, person X has a certain character and therefore they probably acted in conformity with that character here. This is exactly the sort of thing that prohibits. And that's what I have there. But with these questions in mind, let's get to the text of the rule itself. It's Rule 608A. Witness's credibility, attack, or supported reputation or opinion. And those two distinctions are very, very important, reputation and opinion. One significant caveat We can only do the truthful character after the witness's character for truthfulness has been attacked. A significant question here. What does attacked mean? Does it mean formally attacked with evidence of untruthful character? Or can it be something less than that? Can it be by implication during cross-examination? Could it be by implication even as late as closing argument? We have to reopen the evidence if opposing counsel implies that this person has an untruthful character based on other evidence that has been admitted in the case. And also, how literally should we read the rule, the term, attacked? If you call me a liar in court, I'm likely to think that my character for truthfulness has been attacked. And yet, under a literal definition, that's not really true. Somebody could say, Polando's never told a lie in his life, but he is here today. That's not really evidence of my untruthful character, although I would certainly take it that way. We get a really good look at these issues from a recent case from the Indiana Supreme Court, Hayco versus State. Hayco is a child molesting and incest case that will become relevant. And through discovery, the state learns that Hayco intends to call certain relatives about the victim's untruthful character. And the state objects pre-trial, claiming that these folks have a lack of foundation. There's some indication that there are depositions here, so everybody kind of knows what's coming, but it's not entirely clear. The court says, defendant, what I'm going to do is have you do an offer of proof outside the jury's presence to establish what these folks' foundation for their testimony is going to be, and this is what the foundation says. These folks say it's all pretty much the same. I think there are 3 witnesses. They've known the victim since she was born. Remember, they're all relatives. They've spent time with her, and they last saw her relatively recently. Based on this foundation, the trial court sustained the state's objection to the evidence and excluded the witness's testimony. It goes to the Court of Appeals, and then the Court of Appeals, upon the grant of transfers from the Supreme Court, that opinion is vacated, and the Supreme Court says, leading off, well, we understand why this is so confusing, because we've talked about reputation testimony. We talked about the foundation for that. We'll get to that in a moment. But we haven't done it for opinion testimony. They go on then to answer one of our questions from earlier. Yes, this is the same standard for opinion testimony as in Rule 701, i.e. it has to be rationally based on the witness's personal knowledge and helpful to the trier of fact. And they say, I mentioned earlier that the nature of the allegations is significant in this case, and they say credibility is going to be especially important in a case like child molesting, where there are often where there's very little what we call physical evidence. They often tend to be credibility contests, and so this sort of evidence relating to credibility is going to be very significant. I would say impeachment is almost always going to be relevant, and therefore this sort of thing might always be helpful to the trier of fact, but the Supreme Court goes out of its way to say it's especially important in this context. So what does that mean here? The Supreme Court tells us that the personal knowledge can include interactions or observations with the witness. I think this is interesting in that very, very few people just lie constantly. So how many lies do you have to tell before you acquire an untruthful character? Is it 1/3 of your interactions with this person, 1/4? I'm not entirely sure. My guess is that we weigh the lies a lot more heavily than we weigh the truth. We tend to presume that people are telling the truth. In fact, the last I looked at the model jury instructions, they instructed the jury to presume that witnesses are telling the truth. And I think we do the same in our everyday lives as well. This is one part of the Supreme Court's opinion that I really liked, and it really helped me understand this issue. They go out of their way to say that the foundation here is less stringent. It's a lesser showing than is required for opinion testimony. Why? Because when we're talking about our opinion of someone's truthfulness, we're just talking about ourselves. I think this person is a liar. I think this person is truthful. When we're talking about the reputation, we're talking about potentially a lot of people's opinions. And so just mathematically, we're going to need a much higher showing in that area. And the Supreme Court goes on to say that cross-examination can cure a lot of ills in this area. If the person hasn't actually seen this child in a while, if the child maybe has grown up a little bit since the last time, or if this witness is basing their opinion on minimal interactions, that's something to inquire into on cross-examination. It's the classic weight versus admissibility issue. So applying this rule to the facts of the case, that's the foundation on the left, and the Supreme Court says this should have come in. This is good enough under the new standard. However, the error was harmless. And I thought that was an interesting conclusion given the importance that the Supreme Court said, I think rightly, credibility evidence has in these types of cases. And the Supreme Court pointed out that in this case, some other evidence that maybe shouldn't have come in on this child's character for truthfulness did come in, other than the reputation. Specifically, the victim's mother had texted the defendant himself, basically calling her daughter a liar, and the defendant himself had actually testified in the case and called the child a liar, and the Supreme Court said that ultimately caused them to believe that the error was harmless. Now, I said that the Supreme Court pointed out that they had already clarified the standard for reputation testimony, and they had, and I thought I would go over that briefly. That one is much older, a 2000 case from the Supreme Court. There, the issue was the testimony of a victim's great aunt about the victim's reputation for honesty in the community. This was a child molesting case. That's the foundation that we're provided with. I think it's somewhat similar to the foundation in HACA. And she says, well, okay, if I'm sorry, in response to the question, well, your friends know this victim. How do they know him? That's really all we're told. They know them. When we're talking about a lot of people's interaction with somebody, that's probably about as good as we're going to be able to get. I can't testify when I talk about 10 people knowing somebody else. How does each of them know them? It's going to be at a very high level of generality. And again, that they lived in the same community and they've known them for a while. In this case, the Supreme Court expressly adopted the Court of Appeals test. The reputation has to be held by an identifiable group of people with an adequate basis, sufficient contact to qualify as knowledgeable. I'm not sure how much this test actually adds, but I think it's interesting that here the Supreme Court affirmed the exclusion of the evidence. And so largely very, very similar evidence, and yet I think confirming the Supreme Court's idea that the threshold for opinion is going to be much lower than the threshold for reputation. Yes?
Does this, I mean, I'm taking this to mean that you would, it says must have sufficient contact with that community. So a community could be made up of one family with a lot of members, correct?
That's, I think, a significant difficulty in this area is defining the relevant community.
Because a family is going to have a particular opinion would be, I mean, probably is what's going to happen. And so if 6 people from the same family testify about someone's reputation for truthfulness, it seems to me that maybe I would let it in, but I don't know how much weight I would give that.
And those are all very significant distinctions. And I think it's interesting you said there's 6 people testifying. My wife comes from a small family. That would be a huge percentage of her family. I come from a large family. That would be a very small percentage of my family. When does the acquaintance with the community, when is that satisfied? Right. It probably depends at least in part on the size of the community.
Right.
So those, yeah, I think this is extraordinarily difficult. I want to loop back around to another question that I asked at the beginning. Is bolstering prohibited, and is this testimony the sort of thing that's prohibited when we talk about bolstering? The rules of evidence do not contain the word bolstering. The idea, I have a 7th Circuit opinion there. I think that's a pretty good definition. And they say bolstering is prohibited because A, we don't want to sit here all day, and B, we want to make sure that the jury is actually focusing on what the witness is saying, not who the witness is. So I think this is actually, to the extent it's relevant, or I'm sorry, I shouldn't use that term, to the extent that it matters, what we have here is a Rule 403 balancing issue. There is not a rule that says thou shalt not bolster. Rather, this is part of the court's general gatekeeping function to keep the trial moving along with relevant evidence. So in other words, is this bolstering? It sure is, but it's proper bolstering. Moving on. this is another area that's quite difficult, and that is how do we protect the record by properly objecting to the admission of evidence on which the court might be said to have already ruled. In other words, how do you properly lodge a continuing objection? Here we'll start off with the rule itself. Rule 103A says if you want to claim error, that is, if you want to appeal, you shall object or move to strike, and your objection shall state the ground for the objection. Easy enough. And then 103B essentially says the opposite. Once the court rules definitively, you need not renew the objection or offer a proof to preserve the claim of error. Reading that, just if this was the first time I'd ever encountered this idea, if I read that, I would say, great, I can object once, and then if it comes up again, I can sit on my hands. That would lead you into an error, as we will see. Here we have, I think, a conflicting policies issue. The whole point of this is not to relitigate every single evidentiary ruling once the court has indeed ruled definitively on it, but we also want to make sure that we preserve the record, and for very good reason, as we will see. I think this is also a jargon issue. If I don't need to renew my objection, does that mean when the court says, do you have an objection, can I respond, we have no objection? As we'll see, the answer is no, do not do that. And then finally, we have an extraordinarily significant, I'm tempted to say, other than rules that just don't even transpose onto one another, I would say this is the most significant federal-state difference in the rules of evidence. The Indiana rule, again, says once the court rules definitively on the record at trial, the objection need not be renewed. The federal rule says either before or at trial. In other words, your motion in limine or your motion to suppress will probably be good enough in federal court. Those of you who practice in federal court can correct me on that if I'm wrong. Not going to be good enough in Indiana. Again, I don't claim a whole lot of knowledge on the federal court system, but my guess is this reflects the increased importance of motion practice in the federal courts as opposed to the state courts. And the appellate courts are sticklers on this rule. I found this case to be particularly interesting. Indiana Supreme Court case from 2010. Pretty common set of facts. We have a motion to suppress, the trial court denies it. When it comes time to admit the evidence at trial, the trial court says, defense counsel, do you have any objection? Counsel says no objection. And then you can almost see this poor guy sweating because we're told that while the jury is out, they're apparently still on the record. And I apologize for the words, but for the wordy slide, but I think it's important. You can just kind of see him say, just so we're clear here, when I said no objection, I meant I was restating my prior objection from the motion to suppress. Unfortunately, while this jury was deliberating, it turns out that they were convicting Mr. Brown, and this is what the Supreme Court held. This failed to preserve the challenge. We need a contemporaneous objection. The rule says timely, contemporaneous. In other words, it needs to be done while the trial court can still do something about it. And again, this applies at the bottom there, whether or not the appellant has filed a motion to suppress. Now, this rule always struck me as unduly harsh. Right? Wasn't everybody on notice that the defendant objected to the admission of this evidence? That was the whole point of the motion to suppress. And in fact, I would contend that, at least in my experience, the motion to suppress, the separate pretrial motion to suppress, is going to be more thoroughly argued, more thoroughly briefed than simply objecting when we have a jury sitting there. Don't we want to encourage the motion to suppress rather than diminish it? And I think all that is true, but I think the Supreme Court is also correct that you need to give the trial court an opportunity to consider the issue in light of fresh developments and correct any errors. Maybe the testimony at trial is slightly different, but different enough to make a difference to the court than it was in the motion to suppress. And here the Supreme Court points out, what could the court have done? Could the court have called the jury in while they were deliberating and say, hey, do you remember that evidence of X? Don't remember that. That's the only remedy is a mistrial, and that's what they say, and I think they're probably correct. So they make this distinction between the continuing objection, which is perfectly acceptable, and the resurrected objection, and that's not going to fly. So what is the advocate to do? You made your objection, the court's ruled on it, and now you have evidence that you think is covered by your original objection. You don't want to rehash the same argument. That's the whole point of Rule 103B. You don't want to waste everyone's time, but you also want to make sure that you adequately protect the record. And we get one of the clearest pieces of legal advice that you're ever going to see, I think, from the Court of Appeals. This is just last year. If you think you have a continuing objection, you say, I am relying on my continuing objection under Evidence Rule 103B. I have never seen it specifically prescribed to say, this is the rule that I'm relying on. 99% of the time, I don't think that's necessary, although frankly it is helpful if we all know where we're looking. But I think this is very, very good advice to say, this is what I'm doing, continuing objection, Rule 103B. And that gives, incidentally, gives the trial court a chance to say, no, I don't think your prior objection covers this. I think this is different. Maybe the trial court's right, maybe the trial court's wrong, but that gives you permission as the advocate to say, oh good, I can launch into my objection again. Maybe with the same result. I'll conclude this section with the continuing objection with a reminder of just how important protecting the record is. This is the shortest for publication. I haven't done any research on this. I'm just going off of memory. So don't give me counterexamples. But this is the shortest for publication opinion I have read. And I think it might be the shortest Court of Appeals opinion, period, that I have read in my time as a lawyer in this state. There's a motion to suppress. The defense counsel says no objections. Again, we know that's a bad idea. But appellate counsel says, hey, this is no big deal. What do you do when you have error and it wasn't objected to at trial? We just say fundamental error. Court of Appeals says, nope, that doesn't work. Even fundamental error does not work if you expressly say no objection. I have a little but see there. There's another relatively recent case where the Court of Appeals said we don't review these things, but because we like to review things on the merits, we'll go ahead and review and you lose. Anyway, I'm not sure if this is really a significant distinction. I'm not sure how evidence comes in under fundamental error if the defense counsel states no objection. Because when we're talking about fundamental error, we're talking about constitutional rights. If we're talking about constitutional rights, we're almost certainly talking about criminal appeals. 99.999% of criminal appeals obviously come from criminal defendants, and criminal defendants don't bear the burden of proof, so it's almost always the state entering evidence. And I have never been in a courtroom in this state where when one side attempts to introduce evidence and the judge asks, is there any objection? The lawyer literally says nothing. They have to say something, right? And so if there's an objection, then they make it. Or if there's not, they say no objection. The only time I can think of where something could be then fundamental error but not objected to is if a witness gives some kind of really non-responsive, highly prejudicial answer, and nobody thinks to object to it or move to strike. But other than that, I have a really hard time coming up with a factual scenario. Any thoughts, comments before we move on? All right. Judicial notice, and specifically judicial notice of court records. Here again, I think we have a non-intuitive pitfall. It's really hard to distinguish between the judicial facts that are noticed in court records and the actual content of those records, especially because it will almost always potentially run afoul of the hearsay rule. This is an area where really looking closely at the text of the rule can help solve the problem. Rule 201A, that's the title of it. There are kinds of facts that may be judicially noticed. But then the rule switches, I think somewhat helpfully, between two terms. We can judicially notice facts that are not subject to reasonable dispute, accurately and readily determined. Classic example, it was March 22nd of 2012, a Tuesday or not. That's judicial notice. Is Mishawaka in St. Joseph County? That's judicial notice. When it comes to court records, we use a very different term. The court can take judicial notice of the existence of court records. their existence, and then the implication from the rule is only their existence. I'll give an example. I just pulled up a random criminal case. I tried to find one that was closed, and it didn't take me very long to find something that looked like this. You can see in the top left there, this document is filed in a criminal case, and it's now, therefore, a record of a court of this state. So can the court take judicial notice of this document? I think so. I think the existence of the document. But you probably can't read it. I was hoping to get everything all on one slide, including the file stamp. But we are told in this that there's a police officer who says that a Mr. Sellner told him that Ms. Steins told Mr. Sellner that her car wasn't working. So under the judicial notice rule, can we take judicial notice of the idea that Ms. Stein's car wasn't working? I don't think so. Even though it's contained within the court record, it's not the existence of the record. Now you're talking about the content of the record. One of the better formulations of this rule comes from Judge Barnes a few years ago in a Chins case, where the Chins court had taken judicial notice of the preliminary inquiry in the case, which made all sorts of allegations against the parent, and then the court considered all those allegations as substantive evidence against the parent. And the Court of Appeals, I think, rightly reversed that determination, saying, no, you look at the existence of the record. The fact of the record's existence can be judicially noticed, but not all facts contained within that record. Completeness. This is an area where jargon really throws us off, and I have to say that in preparing for this talk, I realized that I was misunderstanding the rule of completeness, and I'm very much hoping that I wasn't the only one. If you were to ask me, what does the rule of completeness mean? I would say, well, it means that if only part of a document or a recording is admitted, then the other side can say, I want the whole of the document or the recording admitted. That's what the rule of completeness means, right? It sounds complete. Turns out that both halves of my formulation were wrong. Rather, first, we are told that the rule of completeness applies when you introduce all or part. It can be the whole thing of a writing or recorded statement. And the second half is that the adverse party allows any other part of that writing or any other writing or recorded statement that in fairness ought to be considered at the same time. Partial introduction is neither necessary nor sufficient. I think the rule is probably misnamed in calling it the rule of completeness. It ought to be called the rule of context or something to that effect. I'm also going to label this a non-intuitive pitfall because it raises a very complicated issue. Okay, what if the side who introduced only part of the evidence said, well, Judge, I didn't want to introduce that other part because it contains some really inadmissible evidence. Does it now become admissible under the rules of evidence, or I'm sorry, otherwise admissible given the rule of completeness? And Judge Miller says the answer is extraordinarily complicated, but his distillation of the rule is that the courts have held that the rule of completeness will trump the rule against hearsay, but not any of the other evidentiary rules. I thought that the Court of Appeals had a really good analysis of this rule relatively recently. The 2022 case, Arkvest versus Wendell, it's a medical malpractice case. And in this case, one of the doctors who testified, one of the doctors whose evidence was designated, it's a summary judgment case, had another letter from another doctor that was attached, literally attached to the deposition. The implication is that this was admitted as an exhibit. In other words, Dr. X, why don't you look at Dr. Y's opinion, and what do you think about that? And almost as an attempt to impeach the first doctor, it's admitted as an exhibit, and therefore it's attached to the deposition. The other side says, wait a minute, I don't like that, rip off that exhibit, and the trial court says, yes, I'm granting the motion to strike. And Arkvest on appeal says, well, wait a minute, we have a rule of completeness. You can't just go ripping off parts of exhibits. Now it's not complete. And the Court of Appeals affirmed, saying, no, you need not admit the remainder of the statement that are neither explanatory of nor relevant to the portions already introduced. Again, the issue is not whether we have part or the whole document. The issue is whether we're taking something out of context, and that didn't happen here. I want to conclude by saying that I think the evidentiary practice in this community is extraordinarily good at a very high level. But unfortunately, at trial, as we've seen, the stakes can be extraordinarily high. This is a quote, incidentally, from a very good book. It's called 9 Principles for Litigation and Life by a defense attorney named Michael Tiger. And he says that we must wear the rules of evidence like a cloak. You can't expect appeals to bail you out. We've certainly seen that over the course of the talk today. Almost all evidentiary objections and responses are spur-of-the-moment things. So we have a number of pitfalls in evidence law. The good news, though, is that the stability of those rules means that very careful study of them can be extraordinarily rewarding to you and to your clients. Thank all of you for your time. I had deliberately allowed a bit of time for questions. I hope I didn't allow too much time, but if anybody has... Yes?
I'll venture a question.
Sure.
In the family law context, I am increasingly encountering situations where one of the litigants wants to introduce a text message or some text message dialogue. And I'll be damned if the thing's not 3 years long. And there seems to be uncertainty in the course where this issue has come up as to what is appropriate to admit or exclude, how to identify it. I think maybe it's a trending topic. Maybe I'm just behind in getting there. But what are your thoughts?
I think that's a really good question because the text message example makes it really, really difficult in that if you were to look at text, like you say, there tend to be conversations over a very long period of time, obliquely responding to maybe 4 threads ago, so to speak, and trying to figure out how to, I assume you're talking about that in a completeness context?
Yeah, I mean, that's what made me think of it more in the completeness context, even allowing for your explanation of it being really framed by what is contextually appropriate and not just what makes it whole. Because making it whole would be pages and pages and pages.
I think you can make a pretty good argument, even longer than that. You need to go back to the very beginning in order to figure out what we're talking about here. And there, I think that just not having considered it at all, except for these last 5 seconds, I would say that might be less a completeness issue than a Rule 403 issue, in that where the court just essentially has to arbitrarily draw a line so that we're not talking about literally every aspect of your life, which we already do a pretty good job of in family law, frankly. But I don't think there is a good solid answer. That's a good question.
Thanks.
I can pontificate, yeah.
What's your opinion on using motions to eliminate to ask the trial court whether evidence is admissible? I've seen other states do that, rather than trying to do now, trying to say, hey, is this going to come in? There's frankly some cases where that's not coming in, there's no point in calling the jury.
That's a really good question. I think I have done that in courts in this state maybe once or twice, and I may have seen it. You're essentially doing a preliminary hearing on the issue of admissibility. I think it's probably a good. I can tell you as somebody who does it, I would rather sit when I have time and I'm not worried about all the other issues in the trial to actually figure out if we're just going to hone in on one issue. I'd rather do that just for my own sake. But clearly, we all know that's not going to be good enough. I think the court can incorporate its prior findings. In other words, let's say there's a motion to suppress. I do an order denying that motion to suppress. I think I can incorporate that into the record at trial, and that would save everybody some time. It's probably a procedure that could be used in appropriate cases. I certainly don't think there's anything wrong with it, subject to the same requirement that when it comes time for trial, if we're going to be arguing about it, then there needs to be an objection or the offer of proof, vice versa. Oh, yeah, go ahead.
Regarding small claims, they have a little bit looser rules. would something that's hearsay be admissible for the judge to make that ruling, or even if it doesn't technically follow the hearsay rule?
I have actually never participated in a small claims case in my life. So if somebody, one of my many fortunes has been my avoidance of small claims court. So I actually don't know. My understanding is that the rules of evidence don't apply. So my guess is that you're under the same standard as the, I should have pointed out that the idea of requiring reliability in the excluded proceedings from the very beginning of the talk, that the Supreme Court there expressly tied that to the due process clause, that this is a matter of due process. That just because there are no rules of evidence doesn't mean that there are no rules at all. And the nice thing about the due process clause is I can tell you it always applies in everything that we do. And so my guess is that standard would apply in the small claims context. That is, hearsay is probably admissible, but it still needs to have some indicia of reliability. But those who have more, and I would certainly defer to those who have more experience in small claims. Anything else? That's it, then. Thanks very much.